Guys, I know people don't like watching the boring videos and they only like watching the exciting ones. Unlikely people are going to fall asleep listening to this, but it's important. People are getting prosecuted by the police. And I'm now actually, because I'm paying money, lots of people are donating towards Kingsley's case. So if we're paying for the case, then we're allowed to write in with legal representations and submit material if we're funding it. I will try to explain this to people now, right? And you just have to take my word for it. It's not wrong. And I know you get some muppets underneath there reckoning that, you know, they know law more or that this is wrong, but it's not wrong. And it's absolutely simple and clear. Firstly, with Rowley, Mark Rowley, Met Police Chief, right, and the rest of them, right, there's this old pretend myth that police have got poetic license. They don't. Police don't have poetic license because they're not writing directions, writing the law, or asking the government for anything unique that you can create from nothing, right? The police enforce written and codified law in local jurisdictions. That's their job, right? Now, they get used to using certain acts and certain laws regularly. Now, I know they do unique cases sometimes to do with, you know, technical frauds, chemistry labs, God knows what. But when it comes to the nitty-gritty, when it comes to the basic, they've got this habit and this stubbornness when it comes to criminal damage. They just like hitting it with a brick, basically, with the Criminal Damage Act, right? When it says that us, are allowed to use an act of law and we can use any enactment which might be applicable, the enactment which actually happens to be the enactment which is used for the thing that you're doing, which is campaigning to government, petitions to government, right? And the provisions of that enactment that say you can't be prosecuted or held to any commitment, we have got, when it says in any act of law, when we're using the law, this is the law that you use to do this, this is the law that you use to do that. You're not going along doing nothing and then the police suddenly come in with a law and use that law to prosecute you. Oh, I'll use the Criminal Damage Act. No, when we're doing something in the first place, I'm using the law, we're using the law, we're the one using the law, and when the law says you can do this or you can do that, and then when the law says you can use any enactment, right, you can. And particularly when the thing that you're actually doing and what it's related to, like stop Ulez petitions and campaigns to the government, then you are using any enactment, right? Which is immunity enactment, and that's why it's there when you're using those Class F representations. But let's get back onto the police, right? In the Criminal Damage Act, right, as far as I'm aware, at no point whatsoever does it say that the police or prosecutor can use any enactment, right? None. Because firstly, they're not creating or writing anything themselves and they're not engaging in a creative process of law in what they're doing, right? They're looking for people who have broke the law or are doing things that the law says they can't do. And they're using the criminal damage law, right? Now, the criminal damage law perfectly facilitates for rights when they're claimed, when they have to be recognised. It is a little bit more vague about them. And the reason being, because in the majority of circumstances, it's not criminal damage. Because you can do it. And when you can do it and you've got a right to do it, it's not damage and it's not criminal. Now, we've got an act of law, the Town and Country Planning. There's two acts Acts 2007 and 1990 that set out the definitions of what we're talking about in meaning and what we're doing and classifying it. And there is defacement, right? Defacement is not dealt with in the Criminal Damage Act. Defacement is included as a thing which is to be proceeded with in the Town and Country Planning Act. Defacement. It's a word. It means something, and the police don't have the creative license to say, oh, we'll just do them for criminal damage. They don't have the right. At no point, when you're dealing with, as the definition in the dictionary says, in clear English, defacement, at no point whatsoever in the Town and Country Planning Act does it say the person using that act or anyone prosecuting anyone for defacement can use any act, namely the Criminal Damage Act. Can the police chief show me where under defacement in the Town and Country Planning Act does it say that the police chief can use any act? Any act. Creative license. None. Nowhere. None. Nowhere under defacement whatsoever does it say the police or the prosecutor can use any act. We can use any act. The person using the Town and Country Planning Act to do what they're doing, when it's under Class F, I can use any act. You can use any act. When you're putting things there, now does the police officer say he can use any act when he's taking it down? Well, the thing is that the classes are about putting things up. And in fact, for obliterating things and destroying them, you'll find that the provisions under the Act prevent them from doing it. Now, hold on a second. Now, this van, right? This van, we are claiming, not that I've got anything to do with it, but I'm doing the legal representation for it now. This van is currently being used to promote and advertise the Stop Ulez campaigns to government, of which there are at least 3 on change.org and on the House of Commons website, which must really be amalgamated anyway by law and combined, right? It is an installation of an advert and can be identified as a representation to the public, a model. It is being used as a model, and anything that is required to install the model, its installation of the model, of the sign, and of the full representation, it is being used as a public demonstration model under the definition of advertisement, model, sign, or representation. When you're doing theatre, that's a representation. Acting, if you're making a little movie or a film, and anything you need on the set to make that film, right? Now, as for the safety, I'm not saying that, when, people are getting injured or harmed, but we're talking in legal terms, right? Let's get the law right. Now, this is Mark Rowley, Police Commissioner of the Met Police, right? And Mark Rowley is running on pure Dutch courage, on pure, well, I've put Red Bull, which is balls. Well, he probably has to run on it, but they've done that many things legal now that they've got nothing to lose because they've probably broke every law that you can think of. Probably more laws than the public break on a daily basis, right? This is that Town and Country Planning Act. This is Schedule 2, right? Schedule 2 does not apply to us when we are doing models or representations in the public or anything that is concerning their installation, right? The installation of any model or representation to the public. That is giving you creative license. Doesn't say that the police are in a process. We're using the law. We're the ones who are allowed to use it. And this law covers also all defacement of anything from Ulez cameras to posts to street furniture. Nothing in this act says that anyone bringing charges against defacement can use any act like the Criminal Damage Act or can creatively reclassify it as another crime. No, police don't have creative license. Is the police officer writing new legislation? Is the police officer drafting actions that he wants the government to perform, like take the cameras down and demonstrating this or making models of, to exemplify this? No, he's not. Schedule 2. Number 5 of Schedule 2 of Town and Country Planning, where an advertisement is required under these regulations. Well, we require it when we want to put it there. To be removed, well, it's not required to be removed. This is the thing. When an advertisement is required under these regulations to be removed, well, it's not. It's actually not required to be removed because that van and the installation is brought under Class F through the use of the enactment for petitioning the government and under the provisions of that enactment, which is that you cannot be prosecuted or imprisoned by a claim of right or right to petition. You can't be prosecuted. And you're exempt all of the provisions in these rules that require removement or facilitate removal, right? The provisions of the enactment are that you can't be held to any commitments of the act, of this act. The provisions of we can use any enactment what we're using, the enactment that is relevant to what we're doing, and you can't be held to any commitments of this act, which is why you've got express and deemed consent. We've got express and deemed consent to do it. Now, get this. It's not required to be removed. The site shall be left in a condition that does not endanger the public or impair visual amenity. That is section 2(5). So that would be that van on the roundabout, right? You could say that it endangered the public or impaired visual amenity, right? But you've got, in law, deemed and express automatic consent to install any model or sign that you want and however you want to install it, right? Through use of Class F, through the 1688 Bill of Rights enactment. We can use any enactment of what's relevant to what we're doing, right? And that means you got a lawful entitlement to do it. So you're not breaking the law. You're not breaking the law, and you haven't broke the law. Therefore, there's no law for the police to pursue or try you. Given in there's at least one law, this one, or multiple laws that say you can do it, the police chief wants to try and find a law that'll prosecute you with, but how is it defined as damage? When you can make an installation and all the things that you require for its installation fall under the installation of the model. The installation of the model is everything which is required for its installation. You got as you see fit, right? As you see fit. Whether we're installing it, right? It's not damage. And an example of that, or anything you need for fixtures and fittings for sign, model, placard, theatrical representation, braille, public speech, speaker and microphone, filming an advertisement with a drone on site, right? While making such promotional adverts, models or installations, and anything that is required to fit them, right? You can do without being liable for prosecution through the use of Class F enactment of the 1688 Bill of Rights. Now, even if it wasn't a model that requires installation of whatever you need to do to install it or want to do to install it, let's just go with, if the police chief wants to argue on whether it is or is not a model and you have or have not installed it, and whatever it takes to install it shall not be construed as damage, shall be construed as the installation method that you see fit on this occasion, right? Let's just use the defacement model. Let's not even get into, damage. Just with the surface of street furniture is called defacement. Anything pertaining to the surface of buildings and street furniture, cameras, anything, is defacement, not damage. Damage is damage. Defacement is defacement. When we approach defacement, we approach it through the Defacement Act, which is this one. And it's not criminal damage. Shall not be prosecuted for criminal damage because it's not criminal damage, it's defacement. Now, if police officer is looking for criminal damage but finds defacement and wants to try have a go at it for criminal damage because he wants to, just because he happens to have a prosecutor and he can fill some forms in and go it to court and he's stupid enough to process it through court as criminal damage, right? Show me when we first encounter defacement, where in this act, when we find defacement not to be construed as criminal damage, where does it say that prosecuting or pursuing against defacement, as in this act, you can use any act? Any act. Nowhere. None. Nothing. Nowhere in this act following defacement does it say you can use any act to prosecute. None. Nowhere. So what are you doing in the Criminal Damage Act? What is he doing? How did he get into the Criminal Damage Act? Because he completely and absolutely ignored the fact it is defacement. And it's dealt with through that act when he signs advertisements or boards. And when you automatically get deemed an express consent, you automatically get deemed an express consent to attach, fix, install, or whatever. That's the main thing the police don't like. Because with permission comes permission and authority to fasten it in whatever means is required. It comes with the authority of the law and enactment you are using, because you get permission from the law, not from a mayor, not from the police chief, not from a constable, not from a councillor, not from Highways England. You get the permission from the law itself. Nowhere, when pursuing defacement and punishments and fines, that's if you haven't got permission, does it say you can try it as criminal damage anyway? Where does it say you can use any enactment? What the police like to do is, when there's absolutely no creative license at all whatsoever, they like to use creative license. And when there is creative license when it says you can use any act, when we can use any act, then the police pretend it doesn't exist. There is no other act. There is no other enactment. Because the model in the Town and Country Planning Act, the model for the use of any enactment is in all of the other acts to do with petitioning, even through elections, referendums, the whole thing. Because this act covers pretty much anything you can do, from models, signs, representations, pretty much anything you want to do. You can make... Really, you're getting consent from the law not to be liable to prosecution if you make a model. Really. But what can you make it out of? Well, if it's someone's private property or private person, they might want to sue you in civil court or something, right? But you're not prosecuted at common law against breaking the law when you can't be prosecuted. So when it comes to public, this is the thing with the council. All charges from the council, all monies, all fines, all fees, when you got deemed an express consent through Class F, you're not liable to be fined, charged a fine from the council for removal, because you can't remove it. So you've got, as far as the law's concerned, it's not chargeable through fines, fees, or criminal charges, because it's not crime. And this is why in the Criminal Damage Act, in case someone gets lost like a lost sheep and ends up in the act wrongly, like the whole police force, lost sheep, it says, shall not be misconstrued against in defence against a criminal charge, because there isn't any criminal charge. If you're using the right privilege or interest, well, you are using the right. If you're in the Town and Country Planning Act through the use of an enactment, you're using the right to petition. So you are using the right. This is what the magistrates' courts are terrified of, and in blatant, absolute contempt and disregard, as if, you know, it's like the Emperor's New Clothes. They don't think that it's there or exists. Yeah, it is. Because it writes off half they're obsessed with this Criminal Damage Act. Criminal Damage Act. I'll just show you here. So look here. This is part 1, right? Except in the case of an advertisement within Class F, that's what we're doing, all the conditions specified in Schedule 2 are complied with, except in the cases of an advertisement within Class F, except in the case of an advertisement with Class F. So not Class F. All conditions specified in Schedule 2 are complied with. Now, there's a schedule about interfering with cameras and devices. Apparently, they're claiming Class F is not exempt from that, but if you read the provisions of the enactment of the 1688 Bill of Rights, it says that you can't be prosecuted. So, you know, and you can't be held to any commitment. So you don't have to comply with Schedule 2. So this is Schedule 2, like we said. Where an advertisement is required under these regulations to be removed, the site shall be left in a condition that does not endanger the public or impair visual immunity. Well, you'd have to... This doesn't apply. Schedule 2 doesn't apply. So it is not required to be left in a condition that does not endanger the public. It's not required or impair visual immunity. So you don't have to actually remove it. And in fact, they're not even really meant to remove it. Unless that van has been stolen and someone's reported it stolen and they want it back, if it is just there and no one's claiming it, it's been used as a model to represent the Stop Ulez campaign and promote the campaigns, and it includes installation of it, even if it's dangerous to the public. It includes that. Now, one thing that the council can say is that they could. This is the part, right, that I think that we've got them on, right, because it says that if you don't make a proper declaration, like on the sign or on the model, like, you know, this is like for HM government petition, you know, to stop Ulez, or the groups or whatever, then the council or police could argue that they didn't recognise it for the campaign. They don't know it's for the campaign, right? But when it says stop Ulez all over it, so this is the bill of... Not everyone in the group's read this. They should know this off by heart. This is the enactment that we use for all petitioning activities. There is the right of the subjects to petition the king, and all commitments and prosecutions for such petitioning are illegal. Well, it means both houses of Parliament as well, because that's well recognised in law through the Tumultuous Petitioning Act. And if you want to find it, it's here. That is the enactment that we always use. And also, you have to share petitions and promotions through Standing Orders 1458 of the House of Commons, which enforces all models, signs and placards and notices to be in place, really, and not removed. This really should secure posting them in the mail, email, and all those things. It's like the opposite of... You can have, like, you know, they put a ban on the press. Courts can stop the press, but also, like, you know, the Petitions Committee is like a mini tribunal inquiry. It's got powers. It's the opposite of stopping the press. It's because it's subpoena. Instead of subpoenaing the evidence directly to the Petitions Committee, they're subpoenaing it to a section of the public or all of the public through the use of the mail, the post, email, Facebook, YouTube, websites. But the problem is we're never getting any enforcement. Mainly because we've got political parties and they don't like our style. If we had all independent MPs and they were all a little bit more, you know, down to earth, they would be a lot more engaging in things like this. But we don't. We have political party Starmer advocates when he leads the CPS, and no, it's like not our style to do things. We don't do things that way. Well, it's not to do with whether you do it that way or not. It's what's legal. So that van shouldn't have been moved. That van should not have been moved from the roundabout. And a lot of people have been contributing to it. Now, if the person who owns the vehicle has reported it stolen and, you know, they've asked for it back, then fair enough. But we don't know that. All we know that his council have come and collected it. This is the thing. 38 Degrees, the petition site, and I've fallen out with 38 Degrees because they took one of my petitions down unlawfully. But 38 Degrees, what I do support them with is they were going and putting QR codes on the pavement for petitions so people could scan the QR codes, and the council was going and sending cleaning vans to clean them off. That is actually against the law because it's Standing Orders 145A of Parliament share these petitions, right? And the QR codes were sharing the petitions. Therefore, it's an order from... Parliament has got authority to make orders. Well, it's already made the order. It's made the order, you know, and it's given direction to share these petitions. So anything you want to do to share your campaign or raise awareness of the campaign is already enforced through Standing Orders of Parliament permanently because they've got permanent directions to share petitions. If you don't have the power to share petitions, all right, you can't. You've got the power to share them on the streets, verbally, on the telephone, through emails, and it's not just under the normal rights. This is like enforced rights, and that is why it's not just Standing Orders 145A3 of Parliament. It actually is through the use of the enactment, which is the right to petition without being held to any commitments. This is why... in election petitions, they get to use Royal Mail for free. You can send one letter. I'm currently on with arguing that for our petitions and in the newspaper, one advert. You used to be able to have a free newspaper advert, but when the big corporate entities took over, they just like kind of phased it out and like, you know, brushed it under the carpet. There's legal right for one advert in the newspaper because it makes these things official. And, you know, we know that it's been published on the Parliament website, but you don't have to publish it on there. You can put it on 38 Degrees. This is why 38 Degrees aren't allowed to take them down, because it's not their petition. They didn't start the petition, and it's not their casework, and they aren't the petitions committee, and they don't have powers to make orders. The orders have already been made by Parliament anyway to share them, and they're not allowed to. We've got a right to enforce through the enactment. The enactment gives us the right to enforce ourselves. So a lot of the councils in London are already breaking the law by, you know, removing a lot of these things, but no one's taking any legal action against them. You know, we need people to take legal action against them in order to make them stop. But people don't want to raise money like Kingsley Hamilton to prosecute. They don't want to, like, you know, if the police come after them and they get in trouble, and then, oh, you know, I'm in trouble, then, you know, suddenly we get into action. But otherwise, people, you know, will get flyers, will do this, will do that, will, you know, get some, you know, people want to buy flyers and stuff like that. But what we should be doing with all these funds that we're raising, like, you know, Charlotte and Tara, they should be doing. We should be doing things like making YouTube stop taking people's channels down. Matt Hardy, you know, getting Matt Hardy's channels back up and his TikTok. You know, getting the newspapers to give people one free petition advert for free, and possibly even Royal Mail on free post as well. Things like that. And stopping, you know, the police charging people with criminal damage. I've tried to explain this to Extinction Rebellion, but it just won't sink in. The problem is, a lot of people now, with no disrespect to anyone, it's to, you know, like when, just let me try to remember what she's called now. So, you know, like when Claire Dyer was in the car on her way to GB News, and she was saying that, you know, she was like, you know, well, it's kind of like, you know, people are only just starting to realise it's about a lot more than just Stop Ulez. You know, it's about, you know, Black Vanguard, the whole corporate thing, all our food, like bigger problems. This is the thing, you know, we're being obstructed. And there are also other things in voting in elections as well. In that Bill of Rights, it says elections ought to be a free process, ought to be free. Right, which means you've got freedom of right to petition and so forth. Not just like free of charge, but completely free. You know, free. You know, not people aren't charging money for it, and you know, you can really, you know, vote for who you want or write down what you want. Really, the candidates aren't really petitioning us. The candidates aren't really petitioning us. Where we really are petitioning the government for who we want as our representative, right? But in the law, what happened later on is it all got misconstrued as the candidates are petitioning us to get elected. But that's not actually how you see it. It's actually all of the people petitioning the government for who they want as, you know, to be the president or so forth. In the American Constitution, in We the People, right, the problem in England is when it comes down to reading your rights and when it comes down to court, they say that, oh, we don't know. We don't have the authority to read our own rights. You know, when they say the police, oh, I'm going to read him his rights, right? You know? In the it's all, when it comes to courts and judges, it comes down to two things, right? They say that only the judge can interpret a rule or law or make an order, right? Well, in petitioning the government, we are making the law. We are writing what law we want, things that we want to be the law. So we can interpret it because we're writing it, right? Now, obviously, we don't give it royal assent. It's the king who signs it. He's making it into law and the MPs. But we didn't make it. We wrote it or whatever. And also, we're writing the directions down. Now, the thing with in America, in the First Amendment, in the Constitution, you'll notice that at the start of it, it says, "We the people," right? Like in the First Amendment and in the Constitution. It's actually officially made law, as it's not. We know we've got the seal of the president, but he's only given it assent. Who wrote it? It's we the people. So we the people wrote the person who wrote the American Constitution, the First Amendment. He's not done it like at the bottom of it. It says, who have attested, but at the start of it, it's declared it is the people of America. It says, "We hereby the people, we set out these laws," and so the people they've been attributed to writing it. You can always have a publisher who, attributes the work to someone else, or whatever. But, he can be a publisher, or he can have a pseudonym or whatever. It's very, very important. We the people, right, means that the people of America, it says, "We the people hereby," then, setting out the Constitution and laws of America and the amendments, right? So who has got the right to interpret the rules and the law? Well, if there's rules and law in a legal document, the person who's written it, it's officially been declared that the people wrote it, right? So they have the power, the legal right of interpretation, right? Which in England, in most law, they say that, it has to be in a court. When it comes down to it, the judge can make a decision on interpretation and then make an order, right? But for constitutional law, for your fundamental rights, you really need to know what your rights are and if you've got any or not, or else you can't act, you can't do anything. You can't do anything, you wouldn't know what you can and can't do. So you've got to have confidence to act, right? So in the American Constitution, the at least in the constitutional law and the fundamental simple framework, and it's not actually that complicated and written down anyway, in civil proceedings, they say that the civil procedure rules are written in a way and must be written in a way whereby everyone can understand and interpret them. And that is what it is with the Constitution of America, right? So we have the right of interpretation. Now, when you are petitioning the government, we writ the casework, we writ what we're doing and what we wanted and so forth. When the police investigate something, there is no, a policeman has got legislation in front of him, right? And he has to go find people who are doing things, right, that are contrary to that legislation. The policeman didn't write the law, and the policeman's not asking for the law to be changed or making one, right? He takes statements from people. He's collecting information from persons and writing it down, right? And taking photographs, maybe even gathering facts, evidence. He uses that to prosecute against the law. But he didn't write the law, and he ain't making the law up, right? When we're petitioning the government, we're writing what we want. We're the ones making it up. We're the ones writing, what we want to do and what we're doing, right? And people are supporting it. And we are given, we're going about the law, using the law when it says we can do this and we can do that, make models and install signs without permission, and the council can't move them or get in the way, even if they're dangerous according to this law. And defacement is not to be considered as criminal damage. If you're putting you see, this is a model, and we've installed it to promote the campaign, right? This van is a model that we've put for campaign promotion, and including installation. Oh, it's dangerous stuff. Schedule 2, we have to apply with it. It's tomorrow, right? Well, it's damaged. No, it's not. That's the part of the installation of the vehicle. But part of the installation damaged something. Well, you always damage. This is the thing. When you put a nail into something, it makes a hole, right? And when you stick stuff, as soon as you get deemed and express consent, you are allowed to do that. You are allowed to do it. And it's called defacement. And if you're not allowed to do it, if you aren't using an enactment or a right, what happens is you get fined for defacement, but through the Act. Nowhere in the Act, even if you don't have deemed and express consent or aren't using an enactment, nowhere in the Act says that a prosecutor or local council can use any enactment to charge them. Where does it say that? Doesn't say it anywhere. Nowhere. Defacement. So why are people who have defaced things ending up getting charged with the Criminal Damage Act? You tell me. You tell me what? Tell me. Do you know why? Because the police are habituated to doing something like a bull in a field, and when it bull charges, there's no stopping it, and they won't be told. And I don't know why the solicitors and lawyers haven't pulled them on it. The council don't really use the Town and Country Planning Act because they're just allowed to do what they want and they don't prosecute themselves, so they don't need to argue it. They just do what they want. And when it comes to elections for council, that the council use it for, there are quite a lot of restrictions on elections. But that's not a petition to the House of Commons. They're using Class E, not Class F. So the council don't believe in the right to petition immunity, which is why they're telling people to take signs down from over the M32 or over the motorway, where people could be raking in loads of signatures. But yet, they've got illuminated signs and boards all over the top of the motorways now for adverts. The police haven't told the council or the government, that they're dangerous or distracting. So, Bristol Council is breaking the law, telling people to take banners down like Dr. Teslami. She could have got 3 million signatures and got a referendum in England, probably, for that World Health Organisation, if could have put banners up around all the motorways. They just don't know the law. And one of the main reasons is food, because it's like the excess dopamine. Just dopamine bread, dopamine donuts, dopamine. And people don't realise, but their ability to interpret the law is being clouded, and their attention span. I mean, I won't get anyone listening to this video hardly, because they just don't understand it, aren't interested, or don't get it. And then you get like a couple of nupties saying, "Oh, you're wrong," but I'm not wrong, because I've studied it for a long time. I know I'm right. Even, we need to be using all the money, right? We could be doing big things like, getting people's channels put back up, all, Facebook groups, all those type of things. Facebook shouldn't be taking groups down for political causes. Messenger, you should, in law, you really are entitled to send one messenger message to every person, but you can only send 40 a day. How can you get 100,000 signatures? And people in groups, if you put it in the group, not everyone sees it, and, it's kind of cold calling. If you, send someone a nice personalised message, they're usually, happy to sign it, because you've gone out of your way to ask them personally. The only thing with that is Messenger tabs now kind of make it hard for people to see incoming messages unless, you're their friend. But you should be able to just cruise down group lists and copy, but you're not copy and paste, but write their name and make it to the actual person. But just go through the group list, 90,000 people, and ask people to sign. Even tag people in group posts. But Facebook, it's all politically obstructed. Nick Clegg's part of Facebook, and he was Deputy Prime Minister. You'd have thought that he would know all this, but I don't think that he did. It took so long to do it. I mean, one last thing that I was going to make a separate video on this, but in the American Constitution, when you vote for the president in the original Constitution, you just write their name down on a bit of paper, whoever you want to be the president. There are different laws in different states for who can and can't vote. But this is the thing. They say, oh, well, what happens if they don't know, can't read it? Well, that's why, you're meant to be a registered elector, and they know who's signing it, because then they can ask you. There shouldn't be one spoiled ballot paper. If you notice, like, they complain about registering for election, they go out of your way to register. In Atlanta, in Stop Cop City campaign, they've been, lots of legal arguments with, like, the council, over people being registered or not, and have their details down. If their details are down, then you can contact the person and check them, so the council can get in contact with them and verify, right? So, this is the thing. But I think the government at one point pulled this thing where they didn't want people to, made everyone scared of being politically exposed. People don't know who you're voting for, don't know who you're voting for. When you've got big banners up, for petitions, stop Ulez, why does it matter? You should be proud of who you want to vote for and so forth. People commenting on videos and groups, saying that they, oppose certain, Sunak or whatever. People aren't scared of their name being seen when they support or oppose anyone. So, really, the right to petition is a free process where you can write anything down on the bit of paper. Like even write on it, I don't want to vote for anyone. You can write for who you want, and if the government, don't know what you've written, then they've got to contact you to confirm it. That's why we pay taxes, and this is how it ended up with these political parties and only vote for who's the candidate on the ballot and so forth. Otherwise, you can write anyone down, and who you think should be, the candidate. Political parties really taking control and pull the wool over his eyes, and all of it's in contradiction to statute underlying law that says election process should be free and open, and we shouldn't be charged for it. Which is why they put it in the American Constitution. You can't charge you money for it, and you don't have to pay for post in the mail. And I think they ended up. This is the thing with Robert F. Kennedy Jr. is complaining that. He's complaining that they're cheating him or cheating the process or manipulating it. Well, they've done that. The First Amendment made it fair. I think Robert Kennedy's trying to say that, what if there's mistakes on the paper? Well, that's why you're meant to be a registered elector. That's why there's strict rules that you've got to be registered, and you've got to have when you sign petitions, they won't accept it unless you write your full details down. So the problem now when you go into the ballot box, I've realised that is you go in there, you check your name and everything, take your polling card in, but when you go into the booth, it's just a scribble out of paper, we're printed out, tick a box, no one knows who voted. People don't want to know who you voted for, but no one cares now. Everyone's like, on the social media saying boo, 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 or yeah, yeah, yeah to certain people. So it's tosh. If your name was on the ballot paper, then why would you go through, this is what I've realised, why would you go through a meticulous regime to make sure everyone's registered, then make sure that, you get through your letterbox and it's got like a number in the bottom corner of it, but then when you go to the polling station, you go into a booth, you ditch that, and then you got a scrawny bit of paper that you tick a box and no one knows who ticked it. And then if there's any questions about it, then you get discounted at the end and set aside. And they're all wasted votes. So I know that there's usually a smaller number of spoiled ballots, but sometimes it can be a lot. And then you've got people who didn't vote. And then how come it's just these two major parties that are in there? Because they're the ones who get on the ballot. But when they did the Constitution of America, they said you can write down who you want. You're the one who's... Right, this is a question about voting in elections, and this has gone beyond the scope of Ulez now. I know that. I know I've gone beyond the scope of Ulez. But, so, are we petitioning the government for who we want to represent us? Or is the person who wants to be on the government petitioning us? Well, it says it's the right of the subjects to petition the king, but am I the king? Are you the king? Are they petitioning us? It seems like the candidates are petitioning us. Well, if the candidate is petitioning the king to get elected, why doesn't the candidate write a letter to the king and say, oh, I'd like to be the leader of the Conservative Party, please? I, Rishi Sunak, I petition you, the king, make me Prime Minister, right? How's that going to work? Oh, he's getting us all to sign it, I see, right? But, this is the thing. It's Rishi's petition. You know, but whose election is it? Is it Rishi's election? It's my little election. It's Rishi Sunak's election. Just a minute, this is, you know, the election of local representatives, you know, who by the people. The local representatives are petitioning the king for who they want as their local leader, right? So you write down who you think should be the local leader. This is it. You know, this is the problem. So, you know, that's it. Basically, the Americans had it all confirmed in their constitution when they wrote it down in the constitution. They recognised the Bill of Rights that, you know, petitions ought to be free, and they reckon the right to petition. Any person, when they're writing something down by petition, has got freedom of creativity. It's the right of free subject. Now, through that Bill of Rights, you're using multiple clauses like the right to petition, using freedom of election, and using freedom of speech. You combine them together. And I think the Americans understood that in the Constitution. You wouldn't write a whole Constitution to a brand new country up, I don't think, if you got it. Now, they made a couple of amendments in the First Amendment. They added in, you know, some important rights, like you can't be deprived of property or your things without lawful due process. That's from Magna Carta and from the Petition of Right. The English government revoked that provision. I don't know why. Said it was unnecessary. It's not unnecessary because it's important enough for it to be in the First Amendment. So that's why YouTube are taking all those videos down. You know, they're not allowed to seize our things without lawful due process. And you can't have a lawful due process when it's not the law. It's just their policy the minute. But the policy, we're just trying to make out, you know, get you to agree to taking your things. But the Constitution says they can't take your things without lawful due process of oath or affirmation in pursuit of legal proceedings. But what legal proceedings are you taking for a private policy? I mean, it's not a criminal offence, so what would YouTube be doing? Taking you to civil court for breaking their policy? But they take your videos down and then so where's the hearing? Where's the trial? Where's the civil hearing that you broke their policy? There is none. So they're not pursuing lawful due process. They just take your things off you and say you broke their policy. But oath or affirmation is only there for lawful due process. Well, they can't get you to agree to their policy to just take your videos because they can only seize your things with oath or affirmation to lawful due process in law, but not policy. Policy is not a law. Policy is just like an agreement. But if you're agreeing to let YouTube take your things without lawful due process, where is the lawful due process? Many of the times YouTube, the claim they raise is invalid, it's false, there's no information contained that is accurate. I've pulled them up on this and they've admitted it. What about in those? Then in lawful due process, you're meant to give thorough details about, you know, what it is you've done wrong. They're very vague about it. And then when you write to them, they're just giving like the same automated reply every time. They don't enter into dialogue because then they could be legally liable. They're not using lawful due process, oath or affirmation. And I don't know how you can give an oath or affirmation from a person when it's a bot scanning things and making errors. A bot can't write an oath. It has to be subscribed by a human, we the people. If in court proceedings, when you go to court and write a statement, who's writing the statement from YouTube? You can't have a bot. They're prosecuting us on, like, you know, speed camera footage and videos, but the speed camera itself cannot just, you know, turn up in court. It has to be gone back to police headquarters and a person has to process it in a police office, and then they have to put the oath that the video footage is accurate and so forth. The actual machine can't do it by itself because it's still submitted by the police process office and staff and a manager. A human ascribes that it's an oath and the truth of a citizen. It's like, you know, we've got the right to police the law. It's still a citizen who's working for the police, ascribing their oath as a human. You can't have YouTube bot can't have an oath because it's not a citizen. It's not we the people, right? YouTube bot. I mean, is the Earth going to be the programmer? I programmed this to be right, to check everything. That's my Earth. But how can he do that to cover every single instance? Because every single instance is different, and every single instance can have glitches. How does he can't have an Earth to have checked every glitch? You know, and a lot of times, you know, you chase them up and they end up being wrong. But they're not pursuing legal proceedings with you because, firstly, you know, they have to be pursuing court. And if you object, if you appeal, you put your appeal through, and they usually refuse your appeal, right? So if they refuse your appeal, that means that where's the court papers coming through? There is none, because they're not doing an oath of affirmation in law, not even in civil law over their policy. It is no law. If they were oath of affirmation against you that you broke their policy in civil court and they were going to seize your videos, then you're in court. Where is it? You know, I haven't broken a law. I broke your policy, right? Well, by oath of affirmation, then they're going to take legal proceedings in civil procedure, but they're not there because there is no court, because it isn't civil procedure. It's nothing. It's just YouTube's absolute bollocks. It is a company saying we can do what the fuck we want with your stuff, whether you like it or not, and we'll make you agree to it before you use our services. But that's illegal because it says under the article, in Article 6, that you can't do that. You can't take our things without oath of affirmation to lawful due process. You know, I lawfully made a policy and got you to agree with it. Yes, but all right then. So you're taking my thing. Where's the oath of affirmation? Where's the legal proceedings? Oath of affirmation to that we're taking legal action. They're not oath of affirming to. It's like the oath of affirmation is to law process. Law process can only be processed through a court, which is civil or criminal or federal. So where's the court? There isn't one. YouTube think that we swear oath of affirmation. YouTube are getting us to agree to a private company, their own rules they made up, getting you to agree to them, and then they pretend they're making you comply as if they're taking you to court, but they're not. They're not. There is no court. There is no proceedings. They've just taken your stuff. It's absolute tosh. It's just bollock. And in fact, it's criminal. And actually, they haven't got immunity either. Someone's talking about all this immunity. Yeah, the immunity is in for copyright claims, so they're not liable for copyright claims. It's got nothing to do with. They think that they don't need immunity for the policy because no one ever challenges their policy. Well, how do you challenge their policy? Through the courts, right? Well, that's what you're doing when they take your video down. When they take your video down, you want to challenge their policy through the courts. Because they're only doing it through oath of affirmation but you broke their policy. But if you say they didn't, well, where do you resolve it? In court. Well, where is the court? They can't seize your things. Well, I appealed it. I'm appealing. I object. So, I challenge you in court. When you appeal it, you're challenging them. You're not agreeing with them. So, I'll have my videos back then until get a court order that I'm wrong. Where is the court order? There is none because there's too many people for them to take to court because they won't be able to do it. So what Biden's done is he's made them immunity law for copyright and then completely blanked the rest of it. But the fact is, they're breaking the Constitution of federal law, which is treason. Yet we don't see Neil Mohan facing the electric chair or on death row. And Google kind of think that they're kind of funny. That, laughing Santa elves, and they kind of think that it's a joke, it's funny. And they're all this, all the YouTube staff think it's kind of, they're like some sort of superior empire. But what they actually are a and the government love them in California. Oh, build a bigger building, YouTube's the best thing that happened to America. You're great, you're fantastic. No, it's Yeah, they've done a lot of good things for people, you know, made big channels for big people, but what about all the people that they're seizing their effects, their videos, their media, their data that they need, they don't have spare copies of without lawful due process? The amount of YouTube staff, really, that the entire YouTube staff needs to go to prison and have to get new staff. It's that serious, and they'll never do it again. They're not taking it seriously enough. I don't see Robert F. Kennedy having them. Where are the police? Why would... And in fact, they've broken the Constitution of America. That's criminal. So I don't have to take them to civil court. Robert F. Kennedy doesn't have to take them to civil court. Why is Robert F. Kennedy not ringing the police up? If he's a professional lawyer, you know, and say, you know, get round to YouTube and get them arrested. You know, press the button. Where's the Big Bertha button? Got everyone's videos back. Get everyone's channels back up, you know. Where's the big button? This is the thing. Where are the American police? Well, the police in America won't arrest YouTube. I don't know why. This is what Rand Paul was saying, you know. When they're political party affiliated, you know, nothing happens. This is the thing. Why aren't the police in Los Angeles, you know, in California, going around to YouTube, walking into the building and arresting everyone? That's what I want to know. They haven't got immunity from breaking the Constitution of America. You can't. They've got a little copyright clause in an act that says, oh, because you're processing so many copyright claims, you know, you'll be at risk of jeopardy of law because of how many you're doing. You know, that, but you can't. What about jeopardy of law for political campaigns? None of the police in England are granting us jeopardy of law. I'm doing loads of Stop Ulez campaigns, you know, actions. I'm in jeopardy of law. Gail Bradbrook, you know, Roger Hallam, we're in jeopardy of law. We're doing political campaigns. Well, that's funny because, you know, you're supposed to be prosecuted anyway in the first place. I got prosecuted twice, you know, for putting campaign material up when it was the same set of circumstances. That was jeopardy of law. Oh, YouTube can have it. But what we can't, we're actually being absolutely dominated. We're being bossed and annihilated by corporate entities who have not only seized all the money, now they're acting as if they're governments and they don't even have a constitution. And no one would agree to such a constitution anyway. They don't want to talk to you. They give automated replies. They reject every appeal. Oh, but we made a nice platform and it's free. And, you know, you can upload videos. Yeah, no, and, but, you know, until, you know, you start taking them away, taking them down, you know, everything's going all right until, you know, this is the thing. And then they're picking and choosing, you know, people who are successful and not successful. I mean, I won't mind. My channel was going all right. I wasn't that bothered, you know, if it had, you know, I got about up to 4,000 or 5,000 people. I was like, this is okay, you know, I've got a little channel and I'm just going along doing my own thing. You know, I wasn't that bothered. I wasn't bothering no one else. I would do my own thing. And then I don't know what YouTube are playing at. You know, you don't need to be Russell Brand or anyone with, you know, millions of people. But what they do is, you know, you're doing your own little thing, not harming anyone, and then they come and poop on your party. And that's when you get pissed off with other people. But then again, I suppose they've taken all Brand's money from him. So, you know, and then you've got Mr. Beast and whatever, and, you know, Prime with the drinks turning up in the shops next to you. You know, you go across to the shop and oh, there's Mr. Beast bars here, and oh, where do we know I'm all right, Jack? You know, get some chocolate down, you put some weight on, get more dopamine, get doped up, get some, you know, get Mark Zuckerberg's moon flavour down here, you know, get some Prime. Get a bit of Jeff Bezos advertising. Oh, where do we know? Right, Jack, you know, bang more products out. You know, it's excess. And the people who are just, you know, happy to go along nice and steady and normal, we're getting pooped on. You know, we're not even allowed to have next to nothing. Never mind, we're not allowed anything. We're not allowed next to nothing. This is the thing. When, you know, there's beast bars knocking around everywhere, making everyone dumb so they can't even understand their own constitution. This is the problem. But anyway, this video is meant to be about Stop Ulez vans, and I'm going to send it in to the lawyers. And it's basically, this van is being used as a model. You can have a model vehicle of any scale or an actual full-size one. It's being used as a model, and everything that has occurred to put it there, enable it to be there, is part of the process of installation, and claimed under the process of installation, which was required, and in deemed express consent. We're the ones with the creative license, not the police. When you see, Tommy, in this act where it says that you know, if there's a defacement instance, you can use any enactment to prosecute, but it doesn't. So I don't know how the police chief is even, how is he getting onto criminal damage? Because he's kind of like a one-trick pony, and it's not even doing the right trick. It's like a one-trick pony that can't do any tricks, you know. And he's stubborn mule, like a red herring, you know, a red bull, stubborn mule. He's just stubborn. He's like a blunt instrument. I think someone said, I think it was Andrew Bridgen MP who said that MP, that Anderson guy, is like a blunt instrument, but he's just stepped down from government now. This is a thing. Blunt instruments, we're being made into blunt instruments by these high amounts of dopamine that are, you know, blunting people's sharpness. So then when they look at acts of law, they don't quite, you know, they haven't got the attention span to kind of like focus on it properly. And even if they manage to get a bit of attention, then all the meanings and associations don't come through because they're kind of doped up. You know, this is the problem. It takes on concentration.